Hello everyone and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and we are here today to watch a hearing that the judge has set so that the gag order can be discussed. Now, the media coalition has asked for the gag order to be lifted now that Bryan Kohberger has pleaded guilty to all charges, which happened on July 2nd of 2025. And then the state actually said, yeah, that's fine. We're in support of that. That's okay. But then the defense said they don't want that. They don't want that. So there's a hearing happening today. I've got the court feed going, and I will be monitoring it, and we'll switch to it immediately when it starts, okay? But while we wait, which is supposed to start now, so they're already 1 minute late, okay? Please like and share so others can also know that we are live right now and we're going to watch this hearing together. Bryan Kohberger is going to be sentenced on July 23rd of 2025. So if you missed that update, check out the last live stream. It's on the playlist for you. If you don't know anything about this case, you can just click more, which will expand the description box. You can read about the case background there. I'm sure everyone here knows about it, but you never know. Someone might be tuning in for the first time today and being like, wait, what is this case about? It is a quadruple homicide that occurred on November 13th of 2022. The lives lost were Ethan Chapin, Madison Mogen, Kaylee Goncalves, and Xana Kernodle. And Bryan Kohberger pleaded guilty to all charges, all 4 first-degree murder charges and a burglary charge, and will spend the rest of his life in prison. He's facing a charge of life without parole, and by pleading guilty, he avoided the death penalty because it would have been a death penalty case. So if the jury decided they recommend that, which was actually pretty likely because this is like one of the worst cases, you know? If not this, people always say, if not this, then what else, right? Whew, so
5 present today.
Oh, he's actually there.
By video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Wilson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here because that was about information provided to the court. And given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you. All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing because, frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. Lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak, and the state has indicated that they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to
okay.
point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright. The request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further or more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days, I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement, but nonetheless, the right to appeal does not go away because of the waiver. And so I think it is important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
Ms. Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests. So we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.
And just like that, this court hearing, it's done. Okay. So what we just watched was a gag order hearing, and the judge has decided to lift the gag order with some conditions that he spelled out, which would be like that. In most cases, one can only make FOIA requests and get everything, sometimes 30 days after sentencing, sometimes 90 days after sentencing, depending on which state. So just to recap, what happened was that the media had asked for the gag order to be lifted. The state actually said that they don't oppose that. They're fine with it because, so here they said, upon further reflection, the state withdraws its request to keep the gag order in place until after sentencing. They said they withdraw their request now that the defendant has pleaded guilty as charged to all 5 counts of the indictment. His right to a fair trial on the issue of guilt is no longer at issue. And so they said, nevertheless, out of respect for the integrity of the judicial process and the privacy of the victims and their families, as they consider their rights to provide victim impact statements at sentencing, the prosecution team does not intend to make any public statements about this case until after sentencing is concluded. So that's the next big thing in this case would be sentencing, which is set for July 23rd of 2025. And the judge also said that he's going to set it for July 23rd and 24th in case they need an extra day, in case it goes over and they don't have enough time to get through everything on the first day. So we see that in some cases as well, that it could be multiple days of sentencing. I think it could be done in one day, but it depends. There's 4 victims in this case, and maybe all of their family members will want to speak. Some of them have said they don't want to. They've indicated they might not, including Steve Goncalves, Kaylee's dad, said he might not actually even be able to attend because one of his kids is going off to college then, so it clashes with that. And he also just said he just might not. I think the victim impact statements are very important, but at the same time, imagine if they just said, no thanks, we don't want to say anything, he's irrelevant. Just forget about him, because I think it's just my opinion. Kohberger would just also love to be the center of attention one more time, right? So yeah, he's pleaded guilty to everything. He's not facing the death penalty anymore. He will be sentenced. He's facing life without parole. And so that's the next thing we'll be watching together. And so the judge has now said he will lift the gag order, even though the defense, their main concern was the ongoing publicity in the case threatening Mr. Kohberger's safety. So they said, no, they want this gag order to remain in place until after sentencing. And the reasons they gave that would be the most interesting, one would be his right to a fair sentencing. That's not the most interesting, we're getting to the most interesting. One reason was the right to a fair sentencing. The other reason they gave was, there was original gag order in January 2023. It was amended in June of 2023. And that gag order went all the way up until sentencing. So they're like, why can't we just keep that going, right? Just keep it going until after sentencing. But the judge has just lifted that and said this does not automatically convert sealed documents to suddenly unsealed documents, that it will take time to go through those documents from newest to oldest. I think that's pretty cool as well. It's going from the latest documents to the oldest ones in that order, and then redacting what needs to be redacted. Maybe there's minors' names, or, he gave some examples. Redact that before unsealing it for FOIA requests to be made, Freedom of Information Act requests. And so the sealed records will not just automatically become public records. Requests will now, if you make those requests, they'll be denied. And the judge said it will take time to work through all of that. And I'm sure it will. It will take many hours to work through all of that. I think Judge Hippler is very fair. Now let me know, while I read this to you, in the comments, what you think about him lifting the gag order right now. I'm in favor of it. I think it's great. So this was what the defense was worried about, saying the ongoing publicity in the case threatens Mr. Kohberger's safety. As set forth in Section 1, the amount of publicity coming before sentencing, even with the revised order in place, is massive. Now, why would lifting the gag order change that? I get that there'll be more information released, maybe even more books, documentaries immediately, maybe people are already ready, or just things that, of course, we've never heard before. But at the same time, I don't think the publicity could get any worse for Kohberger, right? So further release would only serve to gin up the anger and violent rhetoric already at a fever pitch, the defense said. Again, this court is well aware of the threats posed not only to Mr. Kohberger, but to his family and court staff. And court staff? Oh my word. No, don't do that. At this point, the press has access to every witness who is not an agent of either party. As the court noted in its denial of the motion to vacate the amended non-dissemination order in 2023, the media is not being restrained. Only the parties are being restrained. Well, the media wants to speak to the parties, but okay. And those restraints are reasonable. Both parties had no objection and indeed sought to have the revised order remain in place at least until sentencing. So that whole at least, damn, you wanted it to go on beyond sentencing? Like for how long? Forever? I think they would have wanted forever. I mean, they can only try, okay? At least the defense is showing Kohberger that they're doing the best job they can for him. They're fighting for him, and then when it's done, because he cannot have any appeals. I know people are also speculating that he could change his mind. He could change his plea right before sentencing. I don't think he'll do that, but can you imagine if he did? Just suddenly, you know what? I retracted. Yeah, I'm going to plead not guilty again. We'll be like, wait, what? The trial's back on. So no, he's pleaded guilty. I think he'll stick with that because it'll be so wild if he didn't. They said court security resources were at a maximum capacity on July 2nd of 2025. Oh yes, we saw that. We watched that together. So if you didn't see his guilty plea, wow, that hearing, it's on the playlist and you could find it there, right? Sherry said, lift it soon. Well, yeah, they just lifted it. Thank you so much for being a member for 8 months. The sentencing hearing scheduled for 2 days promises to be even more taxing on those resources. Lifting the gag order, they say non-dissemination order now, is likely to change the atmosphere near the courthouse and may well push security needs beyond capacity. Now, I want to know, of course, what they know for them to think, oh crap, that's going to come out. If they lift the gag order, then that information, whatever it may be, is going to come out and make people even more angry. Is that so, right? So the court, they said, has issued a records hold order and special inquiries ongoing. So the rest of this document is not the most interesting. The most interesting to me was, oh, you're afraid for his safety, especially at sentencing. Oh, I think his safety when he goes to his forever home is what's really in question, right? And nobody could stop all the inmates knowing about everything that went on either. So the conclusion was Mr. Kohberger requests the court deny the media request to vacate the revised order ahead of sentencing in order to maintain the integrity of the process and the security and safety of all parties involved, including the families, court staff, and attorney. The revised order should remain in effect. The judge has denied that. The judge said, nope, we're lifting it, and he's granted the media's request to lift the gag order. I mean, this is a big day in this case. To lift the gag order, I mean, it's been in place since January of 2023. It's been a long time. Can you imagine if we could be a fly on the wall at all those media companies right now? I think everybody's running around at full pace, just ready to interview everybody that they had lined up for when, anticipating that this will probably be lifted next week right after sentencing. Dilo said, I love being one of the Grizzlies. Thank you so much for being a Grizzly. Sherry said, Sherry for justice. He's been wearing a bulletproof vest to court every hearing. It's got to be bad. Well, yeah, he's got to. So that is what we have. So today, that was a huge step in this case. The gag order is lifted. It's actually nice to say those words. The gag order is lifted. It's been in place for so long. I look forward to seeing what comes out now. What are we going to hear next? Who's going to be interviewed and where? If anyone is interested in reaching out to me, they can contact me at grizzlytruecrime@gmail.com. Maybe they want to speak on this platform. The door is open. Just email me, and then we'll see what we can do. So I look forward to watching the sentencing with you. And I will see you then in this case. Of course, there's many other cases that there's lots coming up. And just today we had a live stream right before this live stream. So if you missed that one, there was also breaking news in that case, the case of Sonny Stewart, a paddleboarder who was murdered in Maine. So go and check that out if you missed it as well. So I'm really looking forward to reading your comments. Leave them below. Like after the video, if you're in the live chat, then leave some comments below as well. It helps to boost engagement. It helps to get the word out. And it also, I like to read what you guys are saying, right? So I will see you very soon. In the meantime, stay safe and may there be full justice for the Idaho victims, Ethan Chapin, Madison Mogen, Kaylee Goncalves, and Xana Kernodle. See you soon, everyone. Bye.